Welcome to the 256 Investor with Joshua Davis, the podcast where North Alabama investing meets practical strategy. In this premiere episode, we're diving into a topic every investor has questions about: homeowners associations. Joining us is Adam Dauro, who represents over 200 HOAs and condo associations in North Alabama. From legal loopholes to hidden pitfalls, Adam breaks down what every investor should know before buying into an HOA or condo. Let's get into it.
Hi, it's JD with the 256 Investor Podcast. We're here with Adam Dauro. Adam, do you want to introduce yourself?
Well, it's good to be here, JD. Once again, Adam Dauro. I'm with Hurd, Area and Dauro. That's our law firm, and I do HOA law all the time. Represent about 200 or so HOAs and condos in North Alabama. So this is what I do all day, every day. So happy to talk about it.
Great. It's going to be an interesting conversation because one of the first questions we get from investors, or maybe demands is more like it, is that they may not want an HOA at all, or they have a lot of specific questions about HOAs. I know that these are different regionally, but what is the expectation? Why are they here? Can you give us a brief history of why HOAs were formed, and more specifically, how they are in Alabama and pros and cons of HOAs?
Yeah, absolutely. HOAs started from restrictive covenants. Restrictive covenants are something that binds your property and tells you what you have to do with that property. In the early 20th century, restrictive covenants were frequently racial in origin. So you can't have African Americans in this community. You can't have Asians in this community. So after the Civil Rights Act in the 60s, they changed. But what you saw in the 60s and the 70s, you saw white flight. You had people moving from urban areas to rural areas and to suburban areas. And you ended up with a transfer of responsibility for green spaces, for pools, things like that, from public to private. So a lot of the times municipalities were running public pools, and when they were integrated, they didn't want to run public pools anymore. So these public pools were, concreted in, and then you had these HOAs that were out in the suburbs that had their own green spaces. And they weren't necessarily integrated or segregated, but they were just for members only. So that's sort of the beginning of the HOA revolution. That happened in the 70s and evolved over the next 40 years into what it is now. Now we have 85%, I believe, of new construction is in HOAs. I mean, it's a huge thing in America. Condos and HOAs are a little bit different. Condos happened a little earlier than the HOA revolution, but in Alabama specifically, what we saw, and specifically in Huntsville, we saw a condo revolution in the late 70s, early 80s. Large numbers of condos popped up during the time when a bunch of people were moving to Huntsville for, NASA and for Marshall and things like that. So developers saw this as, we need young professional small places for young professionals to live, and so you have a lot of condo development. Fast forward into the 90s and the 2000s, that's when you start seeing Huntsville begin to suburbanize. You see Madison begin to explode. All sorts of things start, being developed at that point. The HOA laws didn't really begin to sort of come together until the 2010s, after the real property crash in 2008. So that's sort of the way things evolved in Huntsville. Now HOAs are really sophisticated. Covenants can be 40, 50 pages long for covenants that were drafted in the 2010s or forward. But it can be quite complicated, and condos are very, very different from HOAs as well.
So I believe the Alabama Landlord Tenant Law or Act was instituted in 2006, right? Or thereabouts. And that is what we go through in typical residential real estate. So it sounds like the HOA, the rules of HOA governance, I guess, may be sprung out of that Residential Landlord Tenant Act.
It doesn't have a heck of a lot to do with it. HOAs aren't bound by the Landlord Tenant Act. We don't really deal with it at all. That's between you and your tenant. What governs you when you're in an HOA, if you're a landlord, is what the covenants state. But as far as the laws, there was an old set of laws for condos back in the 70s. Then in the 90s, we have a new set of laws for condos, and so they govern newer condos. Alabama HOAs, sort of the Wild West. They've been the Wild West for a long time. We only really have one key HOA statute in Alabama, and it was passed in 2015. I was actually involved in the early drafting stages of that law. And The goal there was to make HOAs in Alabama more regulated to where you know what they can do, what they can't do, how the developers, relate to the HOA, how they turn things over. And we had a lot of great ideas, but the lobbyists came in at that point and sort of everything got hacked and slashed. And so this 2015 Alabama HOA Act doesn't really do a heck of a lot. So I would say Alabama HOA governance, if you're in an HOA specifically, it's a lot more to do with the covenants than with what state law says. We're not like Florida. Florida has a huge and complicated statutory structure as
For
to
good
what.
reason.
Yeah, yeah, and I mean, you know what you can and can't do in Florida. It's very, very easy.
Okay. So that being said, since it is strictly by that association, what are some pros, cons, pitfalls that people fall into? What are some warning signs that one would look out for when they're thinking of investing in a particular area?
Well, from an investment standpoint, the first thing you need to know, and I'm sure you already understand this, and a lot of your listeners probably do, is that when you're coming into an HOA, the single family rental space, it's likely going to be hostile, right? I don't know any HOA that says, hey, let's bring more landlords in. The call that I get probably every other week is, how do we keep landlords out, right? So it's a complicated situation to be in. Condos are very different. Condos, people have been investing in condos for 40 years now. Condos are usually, it's a lower barrier to entry for investment. They're used to having developers and real estate investors come in and rent. HOAs, the explosion in HOA rentals didn't really happen until after the pandemic. You see, I think it was between 2020 and 2022, a very large surge in larger companies coming in, the big national rental companies coming in and eating up a lot of that equity as it was growing in 2020 to 2022. And that's when all of my clients start saying, hey, hey, what's going on? Can we please stop this? Well, the answer is usually you really can't. That there's a lot of ideas that HOA boards have on how to essentially discriminate against landlords, but the legal answer is can't do that. There are certain industry standard things that HOAs can do to sort of drill down on how they relate to landlords. What they've got to have copies of the leases and things like that. But as far as the things I get asked a lot of the times, can we institute rental quotas? Can we charge landlords more? The answer to that is no. So you have to understand you're coming into a situation where a lot of these boards, they're just people. They're not professionals. They don't know how to govern themselves. They don't really have experience in running a corporation because an HOA is a corporation, and so you have to be aware of that when you come into an HOA. However, it's becoming much much more common to see rentals in HOAs as other than just condos.
And how common is it for an HOA or condo association to have a management company running their affairs financially, with grounds upkeep, things like that? I know it's not uncommon, but how common is it between the condos and a homeowners association?
It's becoming more and more common. There's a lot of agencies that are national that manage HOAs everywhere. We have some good local companies that manage HOAs, but I will say if you're in the realm of the 200 to 400 homes in an HOA, you're almost certainly going to be managed because once again, these board members, they're volunteers, they're not professionals. They don't want to deal with architectural review requests and fines for 200, 300, 400 people. If you're in one of these small HOAs that's between 50 and 100, maybe you're self-managed. Some small condos are self-managed, but condos have a lot more to do than HOAs. Condos have got to maintain the building. And so condos are almost always managed.
Right. It's generally a group of 3 to 7 people who volunteer their time. And at the end of the day, they don't want to volunteer a lot of time for something they're not going to earn any commission on. So it does make a lot of sense to hire out a property management company to handle those. That's one thing that I would say an investor needs to look for is, do they have a property management company over a large complex, especially condos, like you said? And what do they do? Do they fulfill financial obligations, or is it just grounds upkeep? Because they can tailor different packages for different people. So I would say that is one thing that investors would need to look for.
And it's better, honestly, in my opinion. It creates some more stability. You have a company that knows what they're doing. It knows how to maintain grounds. It's got a set of contractors that it works with. It's going to have a connection with the lawyer. Yeah, from an investment standpoint, a managed HOA is going to be a better call.
And what is the investor privy to when they're doing their due diligence on a possible purchase? What kind of information can a purchaser obtain, and at what stage can they obtain that information about the HOA?
So the answer is different based on whether you're talking about an HOA or a condo. If you're an HOA, virtually nothing. Okay, so the HOA's disclosure responsibilities under the law are based on the nonprofit code because an HOA is a nonprofit. Those disclosure responsibilities they owe to the members. Well, if you're a prospective purchaser, you're not owed anything. You can ask them, and real estate agents and management companies, they are going to communicate with you, but you can't say, I need this, and this, and expect there to be some legal basis or teeth to what you're asking for.
There's no obligation for them to give it to you.
None at all.
Basically out of the kindness of their heart.
Right. Like, for example, the covenants. Like a lot of people say, hey, I never received this copy of this 40 to 60 page document when I signed. There's no responsibility. There's no legal responsibility for anybody to give that to you. It's in the probate records, and you are deemed to know that it's there, even though, of course, nobody's down at the courthouse looking through all the courthouse records. So, yeah, HOAs, you're not entitled to much of anything. Condos is different. Condos, we have that statutory structure. So you're entitled to get what's called a resale certificate. And there's a certain specific, layout of information they're supposed to give you. So you request the resale certificate, they provide that to you, and that's it.
Okay, and that resale certificate can include financials, a budget, P&L, things like that, insurance information.
A limited amount of information like that. Mostly it's information about the board. Yes, insurance, correct. Information about what the assessments are, what they have been, and copies of the covenants and the important documents.
So with condos, you are legally allowed some amount of information, at least about your potential purchase. But dealing with an HOA, it's like caveat emptor, buyer beware.
Yeah.
It's up to the purchaser to uncover whatever information they can about that HOA, correct?
Right. And if you're dealing with an unmanaged HOA, you might struggle even getting in contact with the board.
Right.
But if you're dealing with a managed HOA, there's going to be a process.
Okay. That's good to know for the investor. I think that answers a lot of questions about HOAs, as some people have been stiffed in the past about not being able to obtain any information. And I've been down that road before. And I can tell you it is very difficult when somebody doesn't want to play ball with you and they don't have to. It can be very hard to get the information you need to make a sound purchase. But with condos, it's a different story. You can get some information, at least to make an informed decision on.
It's much more regulated.
Okay.
Some of the pros and cons of a condo versus an HOA and finances are well worth talking about here, because an HOA, say if you're an investor, you buy into an HOA, you know what your assessments are going to be. They're an annual chunk in almost all circumstances. So you pay, say in January every year, you're going to pay $300, $400, $500, whatever it happens to be. That's your assessment, and that's going to pay for the maintenance of the common area over the course of the year. Condos are frequently you're going to pay on a monthly basis. And so whether you like that or not, it depends. But the important difference between HOAs and condos is HOAs, they have a much lower responsibility for what they actually have to do. Their budgets are lower, their maintenance responsibilities are lower. And so you don't have to worry, you don't have to have this back of your mind worry, oh, what if the assessments go up by, $500 this year? HOAs are usually a little more stable unless something terrible goes wrong. A lot of HOA covenants have language there that say you can't raise the assessments more than 20% in a single year, period, unless you go to all the membership and have a big vote. So that's a little bit more stability in your bottom line cost. Condos, they've got to maintain a large amount of common space and a large amount of common elements, like the building itself, the roofs, the windows, even sometimes roads. And so if you buy into a condo, and I'm sure you've heard these horror stories, you buy into a condo, the next year you get assessed with a $10,000 special assessment to repair the roads. That happens. It happens in Florida a lot. It's happening a lot lately. So that's the one worry you need to have in a condo, is because there is virtually no limit on what most condos can assess you with. And so if they haven't been maintaining their reserves properly over the course of the past 10, 20, 30 years, and now they've got a $300,000, $500,000 project and they don't have the money for it, you just bought in one year, Next year, oh, now I have $20,000 that I have to pay. So it can be a little scarier going into a condo just because of that responsibility. So it's, I think we've gathered condos are better in one way, HOAs are better in another.
It can be unpredictable, but I think one can satisfy a lot of that simply by the eye test. Driving through the complex, does it look like it needs a ton of work? Are all the roofs over 20 years old? And you can judge most of that just by the eye test. Are the windows all rotting? That should tell you that there's going to be a special assessment coming sometime soon.
Mhm.
And if you have the financials, if you know what the reserves are, it's pretty easy to make an informed decision about whether that's a good investment or not.
The reserve, that's the key. You've got to get the information about that reserve.
The reserves, if there's been a reserve study done, is that something that a purchaser it can receive?
You're not entitled to that information.
Okay,
And reserve studies, I always recommend reserve studies. They're fantastic. They're expensive, but they're kind of rare.
right. So yeah, pros and cons. But with an HOA, it may not be as easy to understand what the potential for assessments is for special assessments. They're usually not providing a lot. They're providing a sign at the entrance of the neighborhood, and they're enforcing fines for leaving your trash can on the street too long or parking cars on the street overnight. Those are typically the things that an HOA is going to monitor, correct? It doesn't usually go far beyond that.
Yeah, if you're talking about money and you're going to do the eye test, like you said, look at the pool and clubhouse. The pool and clubhouse is where the big money is going to be in an HOA. So if there's something major that goes wrong, it's going to be the roof of the clubhouse or the liner of the pool. Those are the big expenses that most HOAs have to deal with. And if they've got a healthy reserve, they should be able to handle that. But we're talking, the difference in financial responsibilities for an HOA versus a condo is an order of magnitude.
Right. There are lots of issues that come up when you have a lot of common space, when you're sharing a roof, when you're sharing walls,
Mhm.
when you have electrical and plumbing running through a building of 4 to 8 units, you're going to have a lot of issues. You can have plumbing leaks, fires, all kinds of things. Where does the blame and where does the responsibility go in these situations?
Yeah, so HOAs have to deal with this much less frequently. Condos, though, this is what condos are all about,
Yeah.
and your covenants in a condo are going to be very explicit about this because this is the number one thing that you're going to have to deal with. What happens when the unit on top leaks and leaks into the unit on the bottom? What happens when it damages the common elements versus the private elements? So this is something that everybody in a condo is going to have to deal with. So the core idea that you need to think about is first you got to think about whether the damage that is caused is a casualty or is a maintenance problem. So casualty would be pipe just burst, not my fault. It just happens, or a fire breaks out. If it's a casualty, then you go to the insurance provisions and you figure out how insurance is handled. And in most condos, the question is if the damage is just to a unit or if the damage is to a unit and to some of the common elements. So if the damage is just to a unit, it's usually the unit owner's responsibility to insure against. But if it burns down a whole condo building, well, the condo's insurance is gonna carry that, is gonna handle rebuild. And there's gonna be subrogation issues between the various insurance companies, so it can get pretty complicated, but that's gonna be spelled out in your covenants. The times that I get bigger arguments are when somebody hasn't maintained their toilet or their water heater or something, and that's just a long-standing maintenance failure, and it leaks and it damages the property. Well, in that case, that's negligence, and negligence is treated under the law very differently from casualty. So you actually have to go to that person and say if person in the unit above fails to maintain their bathtub and it leaks and it damages the person below. That's not really any of the association's business. That is a lawsuit between the unit below and the unit above. And so a lot of people will come to the HOA and go, hey, this is your responsibility. You're supposed to keep me safe from these things. And the answer is no, not really. We're not supposed to keep you safe from the maintenance failures of your neighbors. So sometimes insurance is involved, especially if the person below is suing the person above. But that's the real difference. You always got to think, is this a act of God casualty thing that just came out of nowhere, or is it a persistent maintenance failure? Now, if the association fails to maintain its roof and that ends up leaking into your unit, that's the association's problem as well.
And I think this is why so many investors are skeptical about investing in condos at times, is because if they have a unit on the bottom floor, well, guess what? There's going to be a water heater above you. There's going to be a bathtub above you. There's going to be all these things above you. And if it's a heavily investor owned area, it's probably an absentee landlord who has no idea if the water heater's leaking, if the toilet has a bad wax seal and it's leaking. So you get into these situations where there are damages, like you said, due from negligence. That is very difficult to handle. And a lot of people think that it is the association's responsibility to work those things out, but it's not. That's an owner-owner situation,
Right,
correct?
right. That's it.
And I think that's one thing that most most investors are worried about, and for good reason, because it can be very difficult to try to come to an agreement with another potentially absentee landlord.
Yeah.
How do you work those out? That's a very difficult thing. And I think you mentioned you want to keep homeowners insurance for your specific condo for those reasons,
Mhm.
because although the association is going to provide coverage for the shell of the building, which is part of your assessments, it's not going to do anything to help that individual's condo.
Right. Yeah, and there's a lot of arguments that you get into with insurance. You know, the lower owner's insurance is triggered, and then they try to go, subrogate or sue the upper owner's insurance. They can't get in touch with anybody. It can be quite a mess.
I'm yet to see an insurance company just eagerly write a check
Right, right.
without going through the court process.
Yeah,
It's a long drawn out process. That is
yeah.
something to be aware of, is that these things do not typically get settled easily.
One other thing to think about with insurance is, say you do have a situation where the whole condo unit burns down. You've had a fire. HOA or the condo triggers its insurance and rebuilds, but the insurance doesn't pay out enough to rebuild entirely. Who pays for the remainder? Well, what's going to happen is the condo is going to allocate a certain amount of money to rebuilding those common elements, and that's going to be split among all the unit owners. And then they're going to allocate a certain amount of money for rebuilding of the unit, and the unit owner is going to pay for that. Or the unit owner's insurance is going to have to come in and do a sub-insurance situation.
So we've dwelled on some pretty big cons.
Hmm.
What are the benefits of buying into a condo association?
Well, I mean, condos over HOAs, they are used to this type of thing. And so, once again, barrier to entry is low. Condos are usually cheaper, especially in Huntsville. A lot of our condos are older, and so they're not as expensive as buying, because real estate values have gone through the roof over the course of the past 2 to 3 years. So condos are easy. And then you've got this idea that you can offer your renter common elements. I mean, you've got a pool. Hey, that's a good draw for renters. And I mean,
Yep, grounds maintenance is taken
yeah,
care of, no
yeah,
lawn
you don't have
care.
to worry about that stuff.
Right.
Right.
Trash is usually provided by the association, so that's not something the renter has to pay for. So there are advantages to the renter. That's something that an investor could advertise, is that they do have a lot lower expenses as the renter. Sometimes the water's covered, the sewer. Sometimes, well, in the old days, cable TV, that's not such a thing anymore. But there are some reasons, like you said, lower barriers to entry. It can be a good cash flow for an investor.
Lower maintenance responsibilities. You don't have to worry about the roof. You don't have to worry about the structure. That can be a big deal for an aging building. Also, differentiating condos and HOAs. A lot of the times that I deal with landlords and HOAs, you are not there, and HOAs govern the exterior. So if your renter isn't properly managing the exterior, if they're parking on the street when they can't park on the street, or if they're leaving their trash can out, if they're not mowing the lawn properly, well, you, the landlord, are going to get hit for that. They're going to fine you, the landlord. In a condo, there's not a lot of exterior responsibility for you. You buy your square of air within the condo and you do the best you can to keep that up, and then everything else is really handled by the condo. It's just less things to worry about.
Right.
Well, one of the things that I deal with the most in HOA law is how to change things, right? If you've got a certain set of covenants and you don't like what it says right now, what do you do about that? And so the key is, when you're changing covenants, there's two real ways this could happen. If you know, let me say more than two if you're really old. If you're a super old HOA or a super old condo, sometimes In order to change the covenants, you actually have to have everybody sign off on that change, or a certain percentage of the owners sign off. And it can be pretty hard to get signatures from people, especially if you're landlords, you're out of town. How are you going to get that landlord's signature? You might be in New York or Florida or Colorado or somewhere. It's hard to get that person's signature.
Are we talking one half or two thirds?
Could be
Typically,
one half and two thirds of the numbers that I see the most frequently. Modern HOAs and modern condos do this through a vote. So instead of actually having to get a wet ink signature that you file with the probate court, you can have a vote and then the board will report, hey, here are the results of the vote. And yes, once again, you have to get a half of the members to sign off or to vote in favor of the change, or two thirds of the members to vote in favor of the change. And that's a lot easier because one of the things that HOAs, especially sophisticated or managed ones or HOAs that have help from counsel, they have a proxy process. And so instead of, you'll set your meeting, maybe 10 or 15 people will show up to a meeting. Well, how are you going to get two thirds of the members to support something if only 15 or 20 people are showing up at the meeting? Well, you have proxies, and like any corporate, any owner of stock or anybody who invests in a company that actually has shareholder votes, you have your proxy vote and you send that into the board and cast it that way. And when you cast your proxy vote, you're counted towards that number of people that you have to get for your quorum or for any other decision. So if you've got a managed HOA, they're going to understand how to do proxies. If you've got help from counsel, they're going to understand that. So you have a much better chance of getting the changes through if it's popular in the community than if you didn't have help.
what do you typically see that owners want to change in their covenants?
All sorts of things, based on some of the more hot button issues, the arguments. Yes, you have arguments regarding rentals. You have arguments regarding street parking, arguments about how the exterior is supposed to be maintained. And so in any HOA, you're going to have a long list of restrictions, specific restrictions on what the houses have to look like, how they have to be maintained, how people have to, have to behave while they're on the property. Sometimes you have arguments about pets, whether you can have chickens in the community, whether pets can be unleashed, or whether you can have, what are those invisible fences for dogs? I have those arguments all the time. And so if someone is living in an HOA and they want to do something that they can't do, or they want certain people to not be able to do something they could otherwise do, that's the change. It's always about restrictions. When I'm looking at a set of covenants, because people ask me to change their covenants constantly. When I go in, I'm looking for big structural problems. Oh, this is like there's a fire, like you can't charge late fees for assessments, or you can't fine people. Those are the things that I look at and go, hey, we need to probably change that so we can actually enforce our covenants. On the contrary, though, some people don't want covenants to be strictly enforced. And a lot of my clients say, hey, we want to be relaxed about this. We're all neighbors. We want to make sure that everybody feels comfortable, and we don't want to lower the boom on people all the time. And so they would rather amend their covenants to relax enforcement. I've done that too.
But having covenants and actually enforcing those with fines and violations are two different things. So it sounds odd that someone would want to lower their standards. They could just avoid fining people and enforcing those standards. But
true.
you do see that happening where people are actually lowering their standards.
I do see it's rare, but when I tell people, when I get the question, hey, how do we relax this? Well, the answer is HOAs don't really have to enforce their covenants. And
I've seen it many times.
Right, but they don't have to. That there's nothing in the covenant. The covenants will say the HOA may enforce their covenants. They never say must. And so the HOA can choose what it wants to enforce and what it doesn't want to enforce. There's going to be sections in your covenants that state you can grant variances or waivers. HOAs can be as relaxed as they want to be. And there's going to be another section in your covenants likely that says that you can pass regulations to clarify your covenants. And when I say you, I mean the board. So the board of directors of the association can clarify gray areas in the covenants as well. So, there's a lot of things you can change. You don't even need a major amendment.
There are condos here in Huntsville that are 70 to maybe 100% owned by investors, a lot of them out of state. If you got a call from someone who's out of state and they were inquiring about a condo, what would your 45-second guidance or advice be to them?
Check the reserves.
Check the reserves.
It's even less than 45 seconds. That is the number one thing, because like we talked about at the very beginning of this, Huntsville's condos were built primarily in the 70s and 80s. They're aging buildings. Their maintenance costs are going up. Inflation is going up. Everything is going up. And so unless that condo has been adequately raising its assessments over the past 30 years and building a nice, healthy reserve, now is the time when Huntsville, I mean, this is the come to Jesus time for most Huntsville condos, I say. And a lot of them are doing well, but a lot of them are having a time right now where they've got to go, all right, how are we going to handle these maintenance problems? And so there's a lot of changes. And honestly, most of the changes this year and last year have been changes for the better. A lot of condos are getting into better shape than they used to be, but it has to happen sometime. And so what you want as an investor is you want that to have happened already.
Right.
You want the condo to already be healthy before you buy in.
But it is all about the cash.
It's about the cash.
Okay. I've got one hot button topic for you if you want to address it.
Always.
Service animals or emotional support animals. How do these relate in, let's just say, condos as opposed to other residential housing? I think a lot of investors are confused about emotional support animals and service animals, which are two different things, but how they relate to residential, to condos, to businesses. Can you touch on that?
Yes, and we can sort of go 10,000 foot view because regardless of whether you're talking about a service animal, emotional support animal, or a lot of other things, you're dealing with the FHA. FHA and the ADA and condos and HOAs are bound by both of those in different ways. And so whenever you're dealing with something like a disability request, it's a request for a reasonable accommodation or a reasonable modification of the common elements, and to allow somebody to have a service animal or an emotional support animal. That's a reasonable accommodation. Never, ever deal with that situation on your own. Okay, if you're an HOA and you've got a question about, hey, somebody wants to install a pool lift, the handicap lift into the pool. Somebody wants to install a chair ramp into their driveway or into their front door. Never answer that question on your own. Consult counsel immediately, because you can get really, really messed up with an FHA or an ADA problem.
Or a handicap parking spot.
Oh my gosh, yes. Or where people can park. Always, always talk to counsel about that, because it's complicated enough to where I get these questions all the time. The first thing I do is I immediately go look at the text of the FHA, the ADA, and try to figure out what precisely is going on. You don't want to handle that problem on your own.
Are these typically modifications made at the owner's expense and then has to be remodified to its existing structure? That's the way it is in residential housing. Let's say a single family detached house. Someone can build their own ramp if they need that, a wheelchair ramp. They just have to remove it whenever they vacate the property.
Correct. It works the same way for common elements in an HOA or in a condo. If you want some sort of handicapped accessible access to the common elements, you can do it as an owner, and you can request that reasonable modification, but the homeowner has to pay for it themselves, because those common elements, as we talked about at the beginning, these are member only. These are not public areas, and so they're not subject to the ADA. So if the member wants to install the wheelchair lift into the pool, absolutely you can do it, and you should, as an HOA, allow them. You can't say no, you can't do it at all. The answer is absolutely, we'll be happy to help. Unfortunately, you have to pay for it yourself, unless you have done something stupid as an HOA or a condo and you have allowed people who are not your members to use your common elements. You've opened them up for church groups, Bible studies, swim meets, large parties where you just invite everybody, where you can invite everybody in. So as an HOA, one of the key things that I always have to tell my clients, whether you're an HOA or a condo, your common spaces are for your members and their guests. You do not open it up to parties for everybody else. You do not open it up for other people, because when you do that, guess what? You're now subject to the ADA, and you got to do these things on your own time.
So members only.
Members
and
only.
With emotional support animals, ESAs, so there is no restriction, just outright, we restrict animals, period.
Well, what you see most often in emotional support animals and service animals is what you can do with them in the pool. Or whether they have to be attached to you or not. Okay, so those are the arguments I get, is somebody wanting to bring their service animal into the pool, and there's actually, it's pretty clear in the law that service animals, you actually can exclude them from pools just because of health and safety issues. But you do have to treat service animals as they're treated under the law. As an HOA, you can't just say, no, we're not even going to listen to this. We don't care. We've got restrictions on what pets can be in the neighborhood. No, you have to follow federal law regarding service animals and emotional support
So
animals.
even though it's a members only, you still cannot put a blanket restriction across animals.
Absolutely. It is one of those things that you are still bound by that aspect of federal law.
Okay.
Another good thing that I could think about would be governance, how you run an HOA.
Mhm.
This is the thing that people have the most problems with. And man, elections, how to run HOA elections. I cannot tell you. It's probably weekly if that I have somebody call me about, hey, our elections aren't being run properly. Our board isn't running things properly. That is something that you probably need help from an attorney to get done right. Election issues are going to be governed by your bylaws. They're going to be governed by the Alabama Nonprofit Code. And the Alabama Nonprofit Code has changed this year. We have a whole new code that governs all nonprofits from 2025 forward. So you probably, as an investor or as a board member, you probably don't understand that. I mean, attorneys barely understand that. We just got it. So we're working on it right now. So you need help. Do not just try to wing this when you're handling an election. Some of the biggest problems I see in elections for HOAs are misunderstanding what directors and officers are. So if you're an Alabama nonprofit, the people who run an Alabama nonprofit are the board of directors. The board of directors are elected by the members to make the decisions for the HOA. A lot of people misunderstand and think that the members are making these decisions directly. Hey, why don't we get consulted on whether to hire a management company? Why don't we get consulted on whether to, enforce this particular covenant? Well, like America, we are not a direct democracy. I do not vote on legislation in America. I vote for my representative, and that representative goes and makes the laws. Same thing for an HOA and its board. But the biggest mistake I see is when people want to vote for president, vote for vice president, secretary, treasurer. So HOAs will sort of be shooting from the hip. They'll have an election. Somebody raises their hand. I want to run for president. Well, I want to run for president. And so they run against each other, right? That is not how nonprofits work in Alabama. If I am electing a nonprofit director, I just elect a director with a capital D. And that person works with the other directors to make the decisions. And it's a democracy. Then those directors will choose who's going to serve as what office: president, vice president, secretary, treasurer. I see a lot of mistakes where folks have had elections for those offices. And I think I've seen one set of bylaws ever that has people vote directly for offices. So you're not voting for president like you vote, in American elections. You're voting for a director at large, and they get to choose who's going to serve as what position.
And I think that's the most misunderstood thing about the board of directors is that the members are not voting for the positions. They're voting for the directors. And the directors will vote amongst themselves for whether we hire a management company, whether we provide or discontinue pest control service, those kinds of things. It's not a member's vote for all these little things. That's
Right.
why you are hiring, or that's why you are voting for a board of directors to make these decisions on behalf of the condo association.
Yep. And also, people see president and think, oh, that person's important. Like that person's running the show. And also, oftentimes you get the board of directors, the director who is the president. I'm the president. I get to say what happens. You are one person, my friend. You are one person, and it is a democracy within that board. You don't get to say what happens. If you can't get, two or three people on your side, president just doesn't get to say what happens.
The president generally calls the meeting,
Mhm.
things like that, but there's no more power. Like you
It's just
said,
a job.
it's just a job.
Yeah.
It's a title like the other ones. But you traditionally have a president, vice president, secretary, and treasurer. And sometimes members can perform two of those duties,
Mhm.
but not more than two. And sometimes it is limited to which two.
Yeah, if you've only got three directors, obviously you can't have four different offices by four different people. Sometimes if this is rare, but sometimes if nobody feels competent to serve as like the treasurer, for example, they can have somebody from outside the board of directors serve as treasurer. That person's not going to vote on decisions, but they can keep the books.
And I think it should be noted that the directors, they are not limited to members of the association who are paying their dues or properly abiding by the covenants. They're traditionally, some covenants could be different, but traditionally they're not barred from serving on the board of directors. So it is possible to get within your group of 5 to 7 directors, people who haven't paid their dues in years.
Oh yeah, have that argument all the time, and it has to be stated according to Alabama law. If you want to put a restriction on who can be a director, it must be in your bylaws. It's got to be there. And most bylaws say members just elect directors. Some bylaws say members can elect directors, but you have to be a member, or you could be a spouse of a member, but a director can't serve with his or her spouse, for example. So sometimes those are restrictions, but it's actually kind of rare for HOAs to say a director has to be in good standing with the HOA. A lot of time, and this is actually kind of important to investors, your renter could be on the board in a lot of HOAs. I've got one that I just did that. Like the renter ran for the board. Everybody got really mad about it, but I told them, nothing in your bylaws says renters can't run for the board.
There's nothing barring it. I
Right.
haven't seen documents yet that would bar a renter or someone who's not an owner from running. And I think that is one thing that investors should be aware of,
Mhm.
is that you don't know who's going to be serving on the board of directors.
A lot of HOAs, one of the things that they don't want is they don't want non-resident members to serve on the board. So they'll come to me and say, how do we keep landlords off of our board? Well, it's got to be, once again, it's got to be in your bylaws. Your bylaws are probably going to say you either have to be a member or anybody can be a director. And that specific issue wouldn't work at all, say during the period of time when an HOA is controlled by the developer. Well, if the developer's on the board, the developer isn't a member of the HOA, right? Or his employees aren't a member of the HOA. So how could they be directors if directors had to be resident members? It really doesn't work.
I think it's important to know what the culture is and the tradition and the standing. And again, drive through the area and see what it looks like. Those are, because you cannot get all the information you need. Someone who's buying a condo, you're never going to be able to get all the information you need to be totally comfortable. But the best thing you can do is again, look at the standing of it, the eye test, talk to realtors, talk to people who have lived here for a long time, and get their feedback on what that area has been like.
Mhm. Absolutely.
Okay. Adam, tell us once again where we can find you, how we can get a hold of you.
Heard Attorney Dauro LLC is my law firm. It's just a law firm in downtown Huntsville. Happy to answer any questions or help anybody out with HOA work
Thanks. Hopefully we'll get to do this again sometime soon.
anytime.
Thanks for listening, everybody. It's JD. My time's up. I thank you for yours.
That's a wrap on this episode of the 256 Investor Podcast. Huge thanks to Adam Dauro for shedding light on the complex and often misunderstood world of HOAs and condo associations. If you found today's conversation helpful, be sure to like and subscribe, and share this episode with fellow investors navigating the Alabama real estate landscape. Thanks for tuning in. Until next time, stay smart, invest local, and keep building.